Hi, Bill Henshaw here again, and this is a very interesting video that will concern you football fans out there, and there's a lot of it with the NFL. And I'm not going to be talking here about my also very considerable handicapping skills, which I've had to set aside given the stuff happening in the legal arena. But I'm pretty damn good there, too. But what I'm upset about here is the recent announcement, I'm sure you heard it by the Commissioner Roger Goodell, that now the official policy was going to change, that if you walked out onto the field and you took a knee during the playing of the national anthem, it's going to cost you, and it may cost your team, and who knows what ancillary consequences might occur here. Well, my reply to Goodell is, geez, this is about as clear a First Amendment issue as you can imagine. If you haven't heard of it, and your damn legal team hasn't heard of it, look up the case of West Virginia Board of Education v. Barnett. I think it's 319 U.S. 246, where the court reversed the case where this Seventh-day Adventist refused to stand up for the flag and during homeroom in school and got suspended for it. And the court said you can't do that. This is freedom of expression here. You can't be mandated to stand up and be responsive to the flag. It doesn't work that way. That would be the case that covers this. And it would. It's a simple matter. But I'm going to suggest to you players that are in the league and you want to take some action, you say fine. I would send Goodell a letter and say fine. I'm going to walk out there on the field. I won't take a knee. But I'm sure as hell going to flip the flag off while the anthem is playing. And really what's going on, so you people understand it out there, we're not really flipping off the flag. We're flipping off the government it stands for. Which if you don't know, and if you get my document packets at ccaspari@live.com, very modestly priced packets, you will learn that we have what is a de facto national socialist government. And I can prove every bit of it. I don't say it if I can't prove it. So that being the case, that's what we're flipping off in a government that's so desperate to get some sense of legitimacy that I'm sure the NFL was ordered by the Donald to do this in Washington, D.C., and therefore not be quote-unquote disrespectful to the military. Well, wait a minute. To be disrespectful to the military is one thing. Where I have the problem, and where most people should have the problem, is the Pentagon, not your average, ordinary enlisted man who's been thrown into the wake and all he's going to get guaranteed when he sign up is a 6-foot burial plot in the nearest military cemetery. I mean, that's how bad it is. In fact, this past Memorial Day, I thought seriously about going down to the local cemetery and disrupting the proceedings. And I have enough information, I could do a hell of a disruption. But that's what it's all about. I mean, the history we have with wars and this, that, and the other, and what the government does behind our back and behind the scenes so that you never hear about it, that's the real problem. And there's no problem. Anybody wants to stand up and object to that, you can do it. By the way, another case the court decided somewhat later is Cohen, C-O-H-E-N, v. California. And I don't have the citation on that one off the top of my head. I think it's 403 U.S. 315, but don't hold me to it. Where he wore a jacket in the courthouse that said F the draft, and he got convicted for making that statement. And it was a divided court, by the way. This was not the easy 9-0 decision it should have been. But nevertheless, they reversed the conviction because he was, exercising his right of free speech. Not an issue that I would raise. It won this case, mind you, but for reasons we'll talk about later, I would do it a bit differently. But nevertheless, this is a dead bang. This is a no-brainer. And by the way, to you NFL players listening out there, I hope there are some, even if you signed the agreement on the dotted line and agreed to waive your rights, you didn't. That's a right secured by the Constitution. And as the Supreme Court said in the case of Miranda v. Arizona, 384 U.S. 466, page 491, where rights secured by the Constitution are involved, there can be no rulemaking or legislation that would abrogate them. And yeah, this is the same Ernesto Miranda v. Arizona. You hear about it all the time. Oh, you have the right to remain silent, you have a right to an attorney, all this other BS from the damn Bill of Rights. Well, they never tell you about this part of it, but it's there. So you have rights that you simply can't waive. And even if you did, the government would have to prove, or the NFL would have to prove, you made a voluntary, knowing, and intelligent waiver of those rights. That's the reference standard of the Supreme Court once again, and like 97% of what I tell you, I get it from the 904s. Case here is called Johnson v. Zerbst, Zerbst, 304 US 458, and I dead bang damn well know this citation. Voluntary, knowing, and intelligent. You'll see how important it is if you get my document packets and study the issues as to how this system works or doesn't work depending on one's perspective. But that said, I think that solution to the NFL, NBA, anyone else that wants to command you to do something that you don't want to do and can't be commanded to do. So we'll hear how this plays out more later, especially when the season opens. I'll get back to you on this one. Thank you.